Q. D, E, and F are jointly indebted to C in the amount of 9 million. C files a collection suit against D for the amount of 3 million. The complaint alleges that D, E, and F are jointly indebted to C, but that C is only using D in order to avoid additional factual issues, which would just prolong the trial. D files a motion to dismiss on the ground that C did not implead E and F. A. Should the motion to dismiss be granted? Assume that the motion to dismiss was not granted. The court, however, ordered C to implead E and F. Letter B. Is the order of the court proper? And letter C. Assume that C did not comply with the court order. May the court dismiss the case. Assume that the court continued trying the case despite C's not compliance with its order. The court rendered judgment in favor of C as against D for 3 million. The judgment became final. Subsequently, C filed the case against E for collection of 3 million. If you were E's counsel, what would you do? Answer to letter A. No, the motion to dismiss should not be granted. A joint debtor is not an indispensable party, but only a necessary party. Besides, non-inclusion of a party is not a ground for dismissal of an action. Section 11, Rule 3. Letter B. Yes, under Section 9, Rule 3, if the court finds the reason for the omission of a necessary party unmeritorious, it may order the inclusion of the omitted necessary party if jurisdiction over his person may be obtained. In answer to letter C, no, the court may not order the dismissal of the case. Under Section 9, Rule 3, it is not provided that the failure to comply with the court's order without justifiable cause shall be a ground for dismissal. Rather, the pleader is deemed to have waived his claim against the necessary parties not included. Finally, answer to letter D, I would file an answer raising the affirmative defense that C's claim has been waived. Q. A passenger bus collided with a tricycle, resulting in damage to the tricycle and injuries to its driver. The plaintiff's tricycle driver filed a case for damages against the bus owner alone, but did not implead the bus driver as defendant. Judgment was rendered in favor of the plaintiff. The defendant bus owner argues that the judgment was void for failure to implead the bus driver as an indispensable party. Is the judgment void? The answer is no. The judgment is not void. The Supreme Court has held in a similar case that the liability of the bus owner and the driver is solidary since they are joint tortfeasors. The creditor may proceed against all or just one of the solidary debtors. Where the obligation of the parties is solidary, neither of the parties is indispensable, and the other is not even a necessary party because complete relief is available from either. Cerezo v. Tuazon, GR 141538, March 23rd of 2004. Philmarco mortgaged its heavy equipment to the DBP. DBP assigned the mortgage to APT. Subsequently, P filed a suit against Philmarco for recovery of a parcel of land in which the mortgage equipment was located. A final and executory judgment was rendered in favor of P. The APT then filed an action to annul the judgment. It argued that it was an indispensable party and should have been impleaded in the suit filed by P against Philmarco. Should the judgment be annulled? The answer is no. The mere fact that the recovery of the land would necessarily entail the removal of the equipment mortgaged to APT does not make the latter an indispensable party. APT's rights can easily be resolved in a separate action it can file against Philmarco. Republic v. Ears of Magdato, 340 SCRA 115. Q. P filed an action with the RTC to nullify the TCT of A. There was an existing registered mortgage over the TCT in favor of Metrobank. The bank was, however, not impleaded in the cancellation suit. The court rendered judgment canceling the TCT. The judgment became final and executory. Can the bank file an action to annul the judgment of the RTC? If so, in what court should the bank file the action? The answer is yes. In a suit to nullify an existing TCT with an annotated REM, the mortgagee is an indispensable party, since the mortgagee's rights over the property would no longer be known and respected by third parties. The non-joinder of the mortgagee deprived the trial court of jurisdiction to pass upon the controversy. Metropolitan Bank and Trust Company versus Alejo, 364 SCRA 813. The bank should file the action with the Court of Appeals, which has the original and exclusive jurisdiction to annul judgments of the RTC. Q. An impostor, Oliver 1, mortgaged the property to Oliver 2 to China Bank, misrepresenting that she is the real Oliver. Oliver 2 filed an action in the RTC against the bank, seeking to nullify the mortgage on the ground that she is the real Oliver. Oliver 2 did not implead Oliver 1. China Bank filed a motion to dismiss on the ground of non-joinder of an indispensable party. The trial court denied the motion to dismiss. Instead of filing an answer, China Bank filed a special civil action with the CA to set aside the judge's order denying its motion to dismiss. Meanwhile, for failure of China Bank to answer within the reglementary period, it was declared in default by the trial court and Oliver 2 allowed to present evidence ex parte. Letter A. Did the trial court properly deny China Bank's motion to dismiss? Letter B. Did the trial court properly declare China Bank in default? Answer to letter A, yes. The Supreme Court held that Oliver 1 is not an indispensable party as the case can proceed to judgment so long as Oliver 2 can prove that she is the real Oliver. Further, a declaration of the mortgage nullity will not necessarily prejudice Oliver 1 as the bank still needs to initiate proceedings to go after the mortgager, who in turn can raise other defenses pertinent to the two of them. Hence, it is not Section 7, Rule 3 requiring compulsory joinder of parties which applies, but Section 11, Rule 3, which provides that non-joinder of parties is not a ground for dismissal. Answer to letter B, yes. The filing of a petition for certiorari under Rule 65 does not suspend the running of the period within which a defendant should answer the complaint unless a temporary restraining order or preliminary injunction was issued. China Bank versus Oliver, 390 SCRA 263. Q. P filed with the RTC an action to annul the issuance of an OCT registered in the name of A, deceased. P did not, however, implead the heirs of A. A judgment in favor of P annulling the OCT was rendered by the RTC. The heirs of A then filed with the RTC of Lapu-Lapu City an action to annul the judgment nullifying the OTC. Letter A. In an action to annul an OTC issued in the name of the registered owners, are the heirs of such registered owners indispensable parties? Letter B. Should the RTC grant the action to annul the judgment? Answer to letter A is yes. The cancellation of the OCT would certainly strip them of their rights over the property. Answer to letter B, no. The action to annul the judgment should be filed with the CA, which has jurisdiction over such cases. Neri versus Laysen, 339 SCRA 232. Q. P files an action with the RTC of Las Piñas City, Branch 170, to recover a parcel of land co-owned by D. P, however, did not include in his complaint E and F, the co-owners of the land. The RTC rendered a judgment in favor of P, ordering the reconveyance of the land to P. No appeal having been filed, the judgment became final and executory on 10th January 2004 and was entered in the books of entries of judgment on the same day. ENF learned of the judgment on March 10, 2004, and on March 15, 2004, they filed a petition for relief from the judgment with Branch 170 of the Las Piñas RTC. P filed an answer seeking the dismissal of the petition for relief. Letter A. If you were the judge, would you dismiss the petition for relief? Letter B. If the dismissal of the petition for relief was proper, what was the appropriate action that ENF should have availed of, and in what court should they have filed the same? Answer to letter A is yes. The petition for relief cannot be availed of by ENF since they were not parties to the RTC case. Section 1 under Rule 38. Answer to letter B. ENF should file an action for the annulment of the RTC decision with the CA. Section 9, number 2, BP 129. A decision rendered without an indispensable party having been impleaded is a nullity. Q. Is the non-joinder of necessary or indispensable parties the ground for a motion to dismiss? No. Non-joinder of necessary or indispensable parties is not a ground for a motion to dismiss. Remedy of the opposing party is to move that the court order the plaintiff to implead the indispensable party, and if the other side fails to comply, then to move to dismiss under Section 3, Rule 17. Besagas versus CA 371, SCRA 508. The court itself may sua sponte direct the plaintiff to include the indispensable party. Failure to comply is a ground for dismissal under Section 3, Rule 17. We versus Court of Appeals, GR 157605. Q. 7J. A service contractor provided manpower services to Lotte Philippines, Incorporated. Pursuant to this, the private respondents were assigned to provide janitorial, maintenance, and utility services to Lotte. Lotte dispensed with the services of private respondents. The private respondents filed a labor case against Lotte and 7J. The labor arbiter ruled that the private respondent's employer was 7J, not Lotte. NLRC affirmed. The private respondents filed a petition for certiorari with the CA against NLRC and Lotte, insisting that Lotte is their employer, but they did not implead 7J. CA ruled that Lotte was the employer, not 7J, and held Lotte solidarily liable with 7J. May the CA's decision be set aside? Yes. 7J, the service contractor, it is an indispensable party. It is a party in interest because it will be affected by the outcome of the case. The CA did not acquire jurisdiction over 7J. No final ruling can be had without impleading 7J. Lotte Philippines Corporation versus De La Cruz. Q. Who is an unwilling co-plaintiff? An unwilling co-plaintiff is any party who should be joined as plaintiff but whose consent to such joinder cannot be obtained. Q. What is the remedy if there is an unwilling co-plaintiff? He may be made a defendant. The reason for making him a defendant shall be stated in the complaint. Give example of an unwilling co-plaintiff. A. Period. B and C are co-owners of a parcel of land, the possession of which has been seized by X. B wants to file an action to recover possession against X. But C does not want to join B, as he does not want to bother with the expenses of litigation. B may file an action for recovery of possession against X and implead C as defendant for the purpose of recovering from him his share of the costs of litigation. J. Robert Harris and Ellen McLean, the involuntary plaintiff, handling the problem of the unwilling plaintiff, 17 South Texas Law, Journal 399. The reason for making C a defendant, that is, his unwillingness to join B, and in order to make him share in the costs of litigation, should be indicated in the complaint. When an executor or administrator is unwilling or refuses to bring a suit for the recovery of the property or rights of the deceased, the heirs may bring the suit and implead the executor or administrator as a co-defendant. Borromeo versus Borromeo, 98 Phil 3432. Florenzo di Regalado. Q, whose option is to implead the unwilling co-plaintiff, the original plaintiff. He cannot be compelled on the mere representation of the defendant to implead anyone. Imata versus IAC, GR number L 72714. Section 12. Class suit. What is a class suit? A class suit is a suit brought by or defended by a representative, member, or members of a large group of persons on behalf of all the members of the group. What are the requisites of a class suit? The requisites of a class suit are: 1. The subject matter of the controversy is one of common or general interest to the members of a group. Number 2. The persons who are members of the group are so numerous that it is impracticable to join all as parties. What shall the court do if it finds that the requisites of a class suit have been met? The court shall appoint a number of the group which it finds sufficiently numerous and representative as to fully protect the interests of all concerned to sue or defend for the benefit of the group. May a group member who was not appointed as a representative intervene in the class suit? The answer is yes. Any party in interest shall have the right to intervene to protect his individual interests. Q. Newsweek magazine published an article titled "An Island of Fear," which wrote of alleged abuses committed by sugarcane plantation owners against their workers. The sugarcane planters filed a class suit for libel and damages against Newsweek. Was the filing of a class suit proper? The answer is no. Each sugarcane planter has a separate and distinct reputation in the community. Hence, the subject matter of the controversy is not of common or general interest. Otherwise, put the interest must be in the subject matter of the controversy and not merely in the legal question involved. Newsweek Incorporated versus IAC 142 SCRA 170. Various persons claiming to be landowners filed a class suit against Araneta Incorporated, claiming that Araneta had illegally deprived them of possession of their lands. Was the filing of a class suit proper? No. Each landowner has a separate and distinct kind of interest, that is, the size of the land, how the title is acquired, etc. Hence, there is no common or general interest in the subject matter of the controversy. Sulunang Bayan versus Araneta, 72 SCRA 347. An airplane carrying 200 passengers crashed somewhere in the jungles of Agusan. All the passengers and crew perished. 20 relatives of the fatalities filed for themselves and in behalf of the relatives of all those who perished in the mishap a class suit for damages totaling $5 million against the airline. the propriety of the class suit is questioned by the defendant, resolve the issue. A. The class suit is not proper. Under Section 12, Rule 3, a class suit is proper when the subject matter of the controversy is of common or general interest. Here, the subject matter is not of common or general interest, since each plaintiff has a separate and distinct claim for damages. Otherwise put, there must be identity of relief sought. 400 residents of Barrio Ramos initiated a class action suit through Albert, a former mayor of the town, to recover damages sustained due to their exposure to toxic waste and fumes emitted by the cooking gas plant of Top Fuel Gas Corporation located in the town. Is the class suit proper? The class suit is not proper. Under Section 12, Rule 3, a class suit is proper when the subject matter of the controversy is of common or general interest. Here, the subject matter is not of common or general interest, since each plaintiff has a separate and distinct claim for damages. In December 1987, the MV Doña Paz sank after a collision with another vessel, MT Vector, resulting in the loss of over 4,000 lives. In January 1988, a class suit seeking damages of 200 to 400 per thousand per victim, or a total of 1.6 billion, was filed with the RTC against the owners of the ships involved by 27 named plaintiffs in behalf of the class of approximately 4,000 heirs of the passengers who perished. Was the filing of the class suit proper? The answer is no. One of the requirements of a class suit is that the subject matter of the controversy is one of common or interest or general interest to the members of a group. This means that there is only one right or cause of action pertaining to or belonging in common to many persons, not separately or severally to distinct individuals. The object of the suit is to obtain relief for or against numerous persons as a group or as an integral entity, and not as separate, distinct individuals whose rights or liabilities are separate from and independent of those affecting the others. On the other hand, if there are many persons who have distinct separate rights against the same party or group of parties, but those rights arise from the same transaction or series of transactions, and there are common questions of fact or law resulting therefrom, the former may join of plaintiffs in one action against the same defendant. This is authorized by the joinder of plaintiffs rule in Section 6, Rule 3. Hence, a class suit is improper if each member of the group has a separate, determinable interest distinct from that of the others. The relevant rule is Section 6, Rule 3. Request of the heirs of the passengers of Doña Paz to set aside the order of Judge B.V. Ching Kwangko, 159 Scra 263. Q. If a class suit is not proper, what is the recourse of the defendant? The defendant can file an answer raising the affirmative defense that the plaintiff has no legal capacity to sue. The reason is that a class suit not being proper, the plaintiff or plaintiffs has or have no right to sue for the benefit of the class. Rule 16, Section 12, Rule 3, Florence Regalado. Q. Leon, in Manila, sold a quantity of rice for 500,000 to Luis in Baguio and shipped the rice through Rita Transportation. Luis refused to pay Leon, claiming that the rice was never delivered to him. Rita Transportation, on the other hand, claimed that it had delivered the rice to Luis, whom should Leon sue? 80 bar Q1. Leon should sue both Luis and Rita Transportation. Under Section 13, Rule 3, where the plaintiff is uncertain against who of several persons he is entitled to relief, he may join any, all of them as defendants. In the alternative, although a right to relief against one may be inconsistent with a right to relief against the other. Here, Leon is uncertain as to who between Luis and Rita Transportation is liable to him. Hence, he can sue both as alternative defendants. May a defendant whose name or identity is unknown be sued? Yes. Whenever the identity or name of the defendant is unknown, he may be sued as the unknown owner, heir, devisee, or by such other designation as the case may require. However, when his identity or true name is discovered, the pleading must be amended accordingly. Section 14, Rule 3. May an entity without juridical personality sue as a plaintiff? The answer is no. Under Section 1, Rule 3, only natural or juridical persons or entities authorized by law may be parties in a civil action. May an entity without juridical personality be sued as a defendant? Yes, when it has entered into a transaction with a plaintiff. In the complaint, is it necessary to state the names of the persons composing the entity? No. They may be sued under the name by which they are generally or commonly known. However, in the answer of such defendant, the names and addresses of the persons composing said entity must all be revealed. Section 16. Death of party, duty of counsel. What is the duty of a party's counsel in case of the death of the party? If a party to a pending action dies, and the claim is not thereby extinguished, it shall be the duty of his counsel, 1. To inform the court within 30 days after such death of the fact thereof, and 2. To give the name and address of his legal representative or representatives. Failure of counsel to comply with this duty shall be a ground for disciplinary action. When would the death of the party in a pending action extinguish the claim? The general rule is that a person's rights and obligations are transmissible upon his death to his heirs. However, where the rights and obligations of a party are intransmissible by law or by stipulation or are purely personal, the party's death would result in the extinguishment of the claim. Examples are the right to hold public office, the right to exercise a profession or vocation, rights and obligations arising from agency, and the right of a usufructuary. The question as to whether an action survives or not depends on the nature of the action and the damage sued for. In the cause of action which survive, the wrong complained affects primarily and principally property and property rights, the injuries to the person being merely incidental, while in the causes of action which do not survive, the injury complained of is to the person, the property, and the rights of property affected being incidental. Bonilla versus Barcena, 71 Scra 491. Pacific Rehouse Corporation, or PRC, entered into a contract to sell over a parcel of land with Bautista for a consideration of $4.3 million. However, despite the receipt of $6.6 million and repeated offers to pay the balance in full, Bautista refused to execute a deed of absolute sale in favor of PRC. Thus, PRC filed with the RTC an action for specific performance against Bautista to compel the latter to execute the deed of absolute sale in favor of PRC and to deliver the certificate of title to it. Prior to the pre-trial, Bautista died. His counsel informed the court of Bautista's death, but could not give the names of Bautista's heirs and their addresses for lack of personal knowledge. Thus, the RTC ordered PRC to procure the appointment of an executor or administrator for the estate of Bautista pursuant to Section 16, Rule 3. On a special civil action for certiorari to the Court of Appeals, the CA ordered the dismissal of the action for specific performance. The CA held that the complaint for specific performance was an action in personam, since its object was to compel Bautista to perform his obligations under the contract of sale, and hence rendered him pecuniarily liable. As such, the obligations in the contract attached to him alone and did not burden the subject property. Since the action was founded on a personal obligation, it did not survive Bautista's death. Hence, the CA concluded that the dismissal of the complaint by reason thereof, and not a resort to Section 16, Rule 3, was the proper course of action. Was the dismissal of the proper course of action? No. Section 16, Rule 3 allows the substitution of a party litigant who dies during the pendency of a case by his heirs, provided that the claim subject of said case is not extinguished by his death. If the claim is an action affects property and property rights, then the action survives the death of a party litigant. Here, although the CA correctly pointed out that PRC's action is one for specific performance, a closer perusal of PRC's complaint reveals that it actually prays for the delivery of ownership of the subject land through Bautista's execution of deed of sale, and the turnover of the certificate of title in its favor. This shows that the primary objective and nature of the complaint is to recover the subject property itself, and thus is deemed to be a real action, which affects property and property rights over the subject land. Therefore, the death of a party litigant, that is, Bautista, did not render the case dismissible on such ground, but rather calls for the proper application of Section 16, Rule 3 on substitution of party litigants. Pacific Ray House Corporation versus NGO, 12 April 2016. Pedro filed an action against Dencho, who he alleges to be his father, to claim the status of the legitimate child. During the pendency of the case, Pedro died. May the heirs of Pedro be substituted in the action? Yes. Under Article 173 of the Family Code, the action to claim legitimacy already commenced by the child shall survive notwithstanding the death of either or both of the parties. This action is among those that can survive under the revised rules of court. Alicia versus Sempio D. Lifted from the Handbook on Family Code of the Philippines. Does the duty under Section 16, Rule 3 apply to death of a party in cases pending appeal? Yes. Riguera, Filipinas versus CA. What is the purpose of notifying or informing the court of the death of a party? So that the court may forthwith order the named legal representative to appear and be substituted for the deceased party within a period of 30 days from notice. Who is the legal representative of the deceased party? The executor or administrator appointed by the probate court, or if none, the heirs of the deceased. Jose E. Ferreira, Rules of Civil Procedure. What if there is no executor or administrator appointed by the probate court? The court has two options. 1. The court may simply allow the heirs of the deceased to be substituted for the deceased without requiring the appointment of an executor or administrator, and the court may appoint a guardian ad litem for the minor heirs. 2. The court may order the opposing party within a specified time to procure the appointment of an executor or administrator for the estate of the deceased, and the latter shall immediately appear for and in behalf of the deceased as provided for in the fourth paragraph of Section 16, Rule 3. It is submitted that the second option is only available where there are pending probate proceedings, as it is the probate court which will issue the letters testamentary or letters of administration. Where there are no pending probate proceedings, the court should simply allow the heirs to be substituted for the deceased. To order the opposing party to initiate probate proceedings would be unduly burdensome upon him and would result in unnecessary delay. What if no legal representative is named by the counsel for the deceased party, or if the one so named shall fail to appear within the specified period? The court may order the opposing party to procure the appointment of an executor or administrator for the estate of the deceased, and the latter shall immediately appear for and on behalf of the deceased. The court charges in procuring such appointment, if defrayed by the opposing party, may be recovered as costs. Section 16, Rule 3, 4th paragraph. Loreto San Juan executed a will naming Oscar Casa as one of the devisees. Upon Loreto's death, a petition for the probate of his will was filed with the RTC. During the pendency of the probate proceedings, Oscar died intestate. The Aquino law firm entered its appearance as counsel of Federico Casa Jr., who claimed to be one of the heirs of Oscar Casa and their representative. The probate court allowed the appearance of the counsel and the substitution of Oscar Casa by Federico Casa Jr., who had been designated by the other heirs as their representative in the probate court. Epifanio San Juan Jr. opposed the appearance and the substitution on the ground that under Lawas v. Court of Appeals 146-173, priority is given to the legal representative of the deceased, that is, the executor or administrator, and that it is only in case of unreasonable delay in the appointment of an executor or administrator, or in case where the heirs resort to an extrajudicial settlement of the estate, that the court may adopt the alternative of allowing the heirs to be substituted for the deceased. Was the substitution of the deceased Oscar by Federico Casa Jr. proper? The answer is yes. The second paragraph of Section 16, Rule 3 of the 1997 Rules of Civil Procedure is quite clear that the heirs of the deceased may be allowed to be substituted for the deceased without requiring the appointment of an executor or administrator. Hence, the pronouncement in Lawas that priority should be given to the deceased legal representative in substitution is no longer good case law. San Juan v. Cruz, GR 167321. Pedro filed an action to recover possession and ownership of a parcel of land against the petitioners. During the pendency of the case, Pedro died, but no substitution by his heirs was effected. The trial court ruled in favor of the plaintiff. Petitioners assert that the RTC's decision was invalid for lack of jurisdiction, since the heirs were not substituted for the deceased, Pedro. Was the trial court's decision valid? The answer is no. Notwithstanding the general rule in Section 16, Rule 3, a formal substitution of heirs is not necessary when they themselves voluntarily appear, participate in the case, and present evidence in behalf of the deceased. Strictly speaking, the rule on the substitution of heirs is not a matter of jurisdiction, but a requirement of due process. Thus, when due process is not violated, as when the right of the representative or heir is recognized and protected, non-compliance or belated compliance with the rules cannot affect the validity of a promulgated decision. Mere failure to substitute for a deceased plaintiff is not a sufficient ground to nullify a trial court's decision. The alleging party must prove that there was undeniable violation of due process. De la Cruz v. Joaquin. July 28-5, court compared this case with Chitik v. CA 166-19. Paulo filed an action to recover possession of a parcel of land against Deng. During the pendency of the case, Deng, who was without counsel, died. Paulo advised the court of Deng's death and filed a motion for his substitution, but the court did not issue an order for the substitution of Deng. The heirs possessed the land. Judgment was rendered in favor of Paulo. May Paulo enforce the judgment against the heirs? No. The failure to substitute the heirs for the deceased defendant deprived the court of jurisdiction to enforce its decision against them. The rights of the heirs of Deng to due process were violated when they were not given the chance to defend their side in court. Hence, the judgment cannot be enforced against the heirs of Deng. See Ferreira versus VDA de Gonzalez, GRL 11567. In the preceding problem, would your answer be the same if the heirs voluntarily appeared in court and participated in the proceedings therein? No, my answer would not be the same. The voluntary appearance of the heirs and their participation in the proceedings therein cured the defect of lack of substitution. After all, the heirs were now given their day in court. Paulo filed an action to recover possession of a parcel of land against Deng. During the pendency of the case, Deng died. Deng's counsel failed to inform the court of Deng's death. The heirs possessed the land. Judgment was rendered in favor of Paulo. May Paulo enforce the judgment against the heirs? Yes. Here, Deng's counsel failed to inform the court of his client's death. Since the trial court was not informed of petitioner's death, it may not be faulted for proceeding to render judgment without ordering his substitution. Its judgment is thus valid and binding upon Deng's legal representative or successors in interest, insofar as his interest in the property subject of the action is concerned. See Carabeo versus Dinko, GR 190823. Saligumba versus Palano, GR 143365. Florendo versus Caloma, GRL 60544. This case should be distinguished from Ferreira, where the court was properly informed of the death of a party but failed to issue an order of substitution. P filed an action for quieting of title with damages against D. During the pendency of the case, a notice of hearing sent to D was returned with the notation party deceased. D's counsel still continued to appear for D and did not inform the court of D's death. Judgment was rendered in favor of P, ordering D to vacate land and return possession to P. The heirs of D, who are now in possession, contend that the judgment was void since there was no substitution. Are they correct? No. The duty of the court to order the legal representative to appear arises only upon proper notice. The notation party deceased on the unserved notices could not be the proper notice contemplated by the rule, as the trial court could not be expected to know or take judicial notice of the death of a party without the proper manifestation from counsel. The trial court was well within its jurisdiction to proceed, as it did win the case or with the case. Moreover, there is no showing that the court's proceedings were tainted with irregularities. It is the duty of counsel for the deceased to inform the court of the death of his client. The failure of counsel to comply with this duty under Section 16 to inform the court of the death of his client and the non-substitution of such party will not invalidate the proceedings and the judgment thereon if the action survives the death of such party. The decision rendered shall bind the parties successor in interest. The rules to operate on the presumption that the attorney for the deceased party is in better position than the attorney for the adverse party to know about the death of his client and to inform the court of the same and address of his legal representative. Saligumba versus Palanog, GR 143365. A filed a complaint for the recovery of ownership of land against B, who was represented by her counsel X. In the course of the trial, B died. However, X failed to notify the court of B's death. The court proceeded to hear the case and rendered judgment against B. After the judgment became final, a writ of execution was issued against C, who, being B's sole heir, acquired the property. If you were the counsel of C, what course of action would you take? Number 2. Did the failure of counsel X to inform the court of B's death constitute direct contempt? Answer to letter A. Number 1. If I were the counsel of C, I would file a motion to set aside the writ of execution. The Supreme Court has held that the failure to substitute the heirs of the deceased defendant deprived the court of jurisdiction to enforce its decision against them as their rights to due process were violated. Ferreira versus VDA. Number 2. No. Direct contempt is misbehavior in the presence of or so near court as to obstruct or interrupt the proceedings before the same. Section 1, Rule 71. Here, the failure to notify the court was not a misbehavior in the presence of or so near the court as to obstruct or interrupt the proceeding. The misbehavior would, however, amount to indirect contempt as it was a misbehavior of an officer of the court in the performance of his official duties. P filed an action for recovery of parcel of land against D. The trial court dismissed the case, promoting or prompting P to appeal to the Court of Appeals. Pending appeal, P died. The lawyer of P gave notice to the CA of P's death and moved for the suspension of the period to file appellant's brief, pending the appointment of an administrator of P's estate and the probate proceedings. The CA denied the motion for suspension and dismissed P's appeal for failure to file the appellant's brief. Was the CA correct? The answer is no. The death of P extinguished the lawyer-client relationship, and hence, the lawyer had no more authority to act in the case, save to notify the court and give the names and addresses of the legal representative. The CA should thus have suspended the period to file the appellant's brief until a legal representative was appointed and the order of substitution made. VDA de Haberel versus Court of Appeals, DR L42699. The Court of Appeals dismissed the petition under R42 or Rule 42 on the ground that the notice of death was belatedly filed by counsel. Was the dismissal called for? The answer is no. Dismissal of a petition under Rule 42 on the ground that the notice of death was belatedly filed by the counsel was uncalled for. The same is the ground not for the dismissal of the case, but for disciplinary proceedings against the counsel. The CA should have ordered the representatives to appear and be substituted pursuant to Section 16, Rule 3, instead of perfunctorily dismissing the case. Regalado versus Regalado. Is Section 16, Rule 3 applicable to a criminal case? Section 16, Rule 3 would not apply in case of the death of the accused during the pendency of the case. Under Section 4, Rule 111, the death of the accused during the pendency of the criminal action shall extinguish the civil liability arising from the crime. However, Section 16, Rule 3 would be applicable if the civil action for the recovery of the civil liability arising from the offense charge was deemed instituted with the criminal action and it was the offended party who died, in which case he would be substituted by his legal representatives. What is the effect of a transfer of interest during the pendency of the litigation? The action may be continued by or against the original party unless the court upon motion directs the transferee to be substituted in the action or joined with the original party. Section 19, Rule 3. Does Section 19, Rule 3 require the counsel of parties to report any transfer of interest? The answer is no. While it may be prudent for a counsel to report any transfer of interest, Section 19, Rule 3 does not require counsel to do so. Siguen Reina Montesilio ang Aziaco versus Tionglo Sia, February 3, 2016. In case of any transfer of interest pendente lite, is substitution mandatory? No, unless the court upon motion directs the transferee pendente lite to be substituted. The action is simply continued in the name of the original party. For all intents and purposes, the rules already consider the transferee joined or substituted in the preceding ACU, commencing at the exact moment when the transfer of interest was perfected between original party transferor and the transferee pendente lite, the same case. The transferee is joined or substituted by operation of law from the exact moment when the transfer of interest is perfected between the original party and the transferee. Natalia Realty versus Court of Appeals. Section 20. Action on contractual money claims. P filed with the RTC an action to collect a loan of $500,000 from D. P was able to obtain a writ of attachment and attach a property of D. During the pendency of the case, D died. Should the case be dismissed? The answer is no. The case should be allowed to continue until final judgment. Section 20, Rule 3 provides that when an action is for a recovery of money arising from a contract, express or implied, and the defendant dies before entry of final judgment, the action shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. D should be substituted by his legal representative or heir. Section 16, Rule 3. D was substituted by his heir X. P won the case and no appeal was made by X. May P move for the execution of the judgment against X? The answer is no. Section 20, Rule 3 provides that the judgment should be enforced in the manner specially provided in the rules for prosecuting claims against the state of a deceased person. P should file the judgment award in the proceeding for the settlement of the estate of D as a money claim pursuant to Rule 86. P filed the judgment as money claim with the probate court. Does the writ of attachment entitle P to the preference over the other creditors in respect of the property attached? The answer now is yes. The writ of attachment was not dissolved since the main action was not dismissed but continues until final judgment. Hence, P is a preferred creditor over the property attached. Jose E. Feria, 1997, Rules of Court. P filed with the RTC an action for recovery of possession of a parcel of land against D. D died while the case was pending and was substituted by his heir X, who had succeeded D in the possession of the land. P won the case and no appeal was made by X. May P move for the execution of the judgment against X? The answer is yes. Since this is not among the cases provided for in Section 5, Rule 86, which have to be filed with the probate court as a money claim, the judgment may be enforced against X since he had been validly substituted for D. P filed an action for tort against D, who had negligently inflicted injuries upon P. D died during the pendency of the case and was substituted by his heir X. Judgment was rendered in favor of P for $500,000. No appeal was filed by X. May P move for the execution of the judgment against X? The answer is no. This is a judgment for money against the decedent and hence has to be filed with the probate court pursuant to Section 5, Rule 86. Pambusco filed a complaint for a sum of money against D. During the pendency of the case, D died. Intestate proceedings for the settlement of D's estate commenced and notice to the estate's creditors was given to them or for them to file their claim within 6 months from the first publication of the notice. A month thereafter, on Pambusco's motion, the administrators of D's estate was substituted for D in the civil case for collection. The court rendered judgment in favor of Pambusco in the appeal. Pambusco filed a contingent claim covering the judgment award with the probate court. At the time of the filing of the contingent claim, the 6-month period for creditors to file their claim had expired. In due course, the judgment in favor of Pambusco was affirmed on appeal and became final, and thus Pambusco moved that the estate be offered to pay Pambusco. The administrator opposed the motion on the ground that the claim is time-barred since the contingent claim was filed beyond the statute of non-claims. Is the claim of Pambusco time-barred? The answer is no. Where the deceased was substituted by the administrator in the civil action involving a money claim, the estate is deemed to have notice of such claim. The substitution of the deceased in the civil action by the administrator or the descendant's representative is generally considered as equivalent to the representation of the claim with the probate court. Under the circumstances, the filing of the contingent claim ad abundantiorem cautelam by Pambusco was a mere formality. Ignacio versus Pampanga Bus Company, GRL 18936. Plaintiff sued to recover an unpaid loan and was awarded 33 or 333,000 by the Regional Trial Court of Manila. Defendant did not appeal within the period allowed by law. He died 6 days after the lapse of the period to appeal. Forthwith, a petition for the settlement of his estate was properly filed with the Regional Trial Court of Pampanga, where an inventory of his assets was filed and correspondingly approved. Thereafter, plaintiff filed a motion for execution with the Manila court, contending therein that the motion was legally justified because the defendant died after the judgment in the Manila court had become final. Resolve the motion and state your reasons. Under the same facts as A writ of execution as issued by the Manila court upon proper motion 3 days after the lapse of the period to appeal. The corresponding levy on execution was duly effected on defendant's parcel of land worth 666,000 a day before the defendant died. Would it be proper on motion to lift the levy on defendant's property? State the reason for your answer. Number 1 answer to letter A. I would deny the motion for execution. Under the rules and special proceedings, a judgment for money against the decedent must be filed with the probate court as a money claim to be enforced in the manner provided for in Rule 86, Section 5, Rule 86. Hence, the judgment cannot be enforced by execution. Answer to letter B. No, it would not be proper to lift the levy on defendant's property. Under the rules and civil procedure, in case of the death of the judgment obligor after execution is actually levied upon any of his property, the same may be sold for the satisfaction of the judgment obligation. Section 7, letter C, Rule 39. Section 21. Indigent party. Spouses B and C were the owners of a residential and boarding house with a market value of more than $300,000. Their total earnings were more than double the minimum wage of an employee. When the city demolished their residence and boarding house, B and C filed an action for damages with the RTC against the city. They applied for exemption from the docket and legal fees as indigents. The RTC denied their application on the ground that they are disqualified to litigate as indigents since they do not meet the salary and property requirements under Section 19, Rule 141. May B and C still be exempted from paying the docket and legal fees as pauper litigants, even though they do not meet the requirements under Section 19, Rule 141? The answer is yes. B and C may still be exempted if they can prove that they have no money or property sufficient and available for food, shelter, and basic necessities for themselves and their family, as provided in Section 21 of Rule 3. If the applicant for exemption meets the salary and property requirements under Section 19, Rule 141, then the grant of exemption is mandatory. On the other hand, where the applicant does not satisfy one or both requirements, then the applicant should not be denied outright. Instead, the court should apply the indigency tests under Section 21, Rule 3, and use its sound discretion and determining the merits of the application for exemption. Read Spouses Algura versus City of Naga, GR 150135, October 30, 2006. That is the end of Rule 3. Next upload will be Rule 4, and if you have not yet subscribed to our channel, go ahead and hit that subscribe button, and let's study Remedial Law 1 review together. Thanks.